Good afternoon. So it takes 4 lawyers to handle this panel, it seems. I'm going to start with Christoph to give us some background on the title of this panel, because the majority of our audience has probably heard about the thousands of player claims in Austria, through which players have successfully been claiming a refund of their gambling losses in Austria from Maltese licensed operators. How has this happened? What has happened for us to come to this in Austria?
Thank you, Davinia. The starting point of all the player claims lies in 2016, where the High Administrative Court ruled that the Austrian gaming monopoly would be compliant to EU law, whereas the Supreme Court, which is competent to rule civil matters, ruled to the opposite and ruled that the Austrian gambling monopoly would be in breach with EU law, to the effect that Maltese licensed operators should be permitted to offer gambling in Austria without having an Austrian license. Both courts approached the Constitutional Court, which then ruled, unfortunately, in favor of the Administrative Court, stating that the Austrian monopoly is compliant to EU law, and therefore, for the offer of gambling in Austria, you would need an Austrian license. Thus, the Supreme Court has then to amend its judgments, and based on this amended practice of the Supreme Court, we saw the first player claims coming in 2018. These player claims were against the operators, and we have seen in later points in time also claims against directors, former directors, or even group companies of the operators. And even the very first players' claims were supported by litigation funding companies, which financially supported the players and also provided experienced lawyers to them. And what the litigation funding companies did is they created a huge, very successful business model out of the players' claims. And we have seen, even in the last 12 months, newly established funding companies in Austria which want to benefit from this business model. By the time the operators have developed different strategies how to tackle the player claims, and some of them decided not even pay final judgments. And that triggered enforcement proceedings, both in Austria and abroad. And from my perspective and from my daily work, I can say the players were not that successful in the enforcement proceedings in Austria. And even with respect to the proceedings where the players tried to get European account preservation orders, the players were not that successful. And that is where we stand today.
I'm sure there is a number of people in the audience who are wondering what the status is. And I can confirm that from the attempt to enforce in Malta, until today we do not have a final judgment in Malta, not even by a court of first instance, as to whether the judgments delivered by the Austrian courts are enforceable in Malta or not. Some enforcements have been repelled on the basis of procedural errors. The others are still in court being debated as we speak, so we don't have a final position on this. Now, Christian, I understand that obviously the cases in Austria are based on contract law, with the terms and conditions being signed between the Maltese licensed operators and the players. The terms and conditions, in most cases, still refer to Maltese courts and Maltese law. However, the cases are decided in Austria because the players are consumers. However, what about actions in tort where there is no contract? What about cases where Austrian courts have actually said that they are not the courts which are competent to decide cases. Can you expand on this for us? Because it's still a bit quite new and I think very interesting.
Absolutely. Maybe let's just quickly recap the standard player claim so that to make sure everyone's on the same page. As outlined by Christoph, the basis of these player claims is always a contractual relationship, then the nullity of the contract, and then unlawful enrichment. These are the standard player claims we are facing in our daily work. Far too many. Due to established case law in Austria, Austrian consumers have this possibility to file such cases in Austrian law, regardless of provisions of choice of law, choice of jurisdiction in the terms of the operators. As I said, this only applies, and as you already anticipated, this only applies for consumers and cases where the legal basis is a contractual relationship. But cases where the claim is in tort or where the claimant is not a consumer anymore, for instance, because the claim has been assigned from a consumer to a professional process cost financer, such as legal claims holding AG, then the situation changes, and we have to look at these cases very separately, and they need to be evaluated in a different way. Such claims in tort, also already mentioned by Christoph, are, for instance, claims against directors of the operators directly. Here, the legal basis for the claim is a violation of a protective law, and there is already a High Court decision qualifying certain provisions of the Austrian Gaming Act as such protective laws, with the consequence that players have the possibility to directly file claims against directors and piercing the corporate veil. These cases, just to give you the full picture, are completely separate and independent from the claims against the operators. In these cases, we successfully managed to demonstrate to Austrian courts and to convince Austrian courts that they do not have jurisdiction over these cases. And then there is the second group, also already mentioned, where claims have been assigned to professional claimants, and therefore these privileges applicable for the consumers do not apply anymore. And also in these cases, we could demonstrate to Austrian courts and make them understand that they do not have jurisdiction.
Now, circling back to the majority of player claims, perhaps Nicholas, you can answer this question for me. I understand that the cases are heard in minutes in Austria, and to us sitting, from an outsider's point of view, we'd like to understand the basis of this treatment towards operators and their counsel, and on what basis the courts are justifying this.
You know what, Davinia, I'd also like to understand that a bit better, to be honest with you, because it is indeed pretty bizarre. I mean, obviously, for those cases, Christian, that you have just mentioned, where there is, a bit more flesh to the bone, because it's not what we, unfortunately, by now are referring to as the standard player claim or standard player refund case. So if it's not the standard claim, there is a bit more of a real civil procedure. But in the standard cases, Davinia, as you mentioned, that is currently not really the case. These are all civil claims. Under Austrian civil procedural law, that would usually mean you've got a written part of the proceedings where both parties file their written submissions to court. And then you've got the oral part of the proceedings, which usually start with a preparatory oral hearing. Now, that preparatory oral hearing, vorbereitende Tagsatzung in German, basically just means the parties get together with the judge and discuss the further steps to be taken in this procedure. And after that, you've got the evidentiary hearings, where evidence is taken, witnesses are being heard, where the claimant is being heard, perhaps expert opinions are being discussed, etc., etc., etc. Now, what we're currently seeing is that the only part of the oral proceedings that is actually happening, that is actually taking place, is that preparatory oral hearing. which again is meant actually only to discuss what else needs to be heard and discussed in the procedure. So basically, you walk into the courtroom, and the judge looks at you and says, okay, we can actually conclude the proceedings because there's not much more to discuss. And we've had court hearings that were opened and closed, and I know this doesn't sound very positive because it isn't, opened and closed within 2, 3, 4 minutes. Yeah? Now, obviously, and that was the point you were alluding to, that is not in line with Austrian civil procedural law, and that is obviously something you can raise within the ordinary appeal procedure in Austria. However, the second instance courts are reluctant to actually consider these procedural errors, these procedural failures, and basically confirm in most cases, in most standard cases, basically confirm the first instance judgment. And that is why we have now complained to the European Commission, because obviously the way these cases are being handled is not in line with the fair trial principles as stipulated in the Charter and in the Convention, because there is no actual oral part of the hearings. Claimants aren't being heard, yeah, and obviously very often we as defending counsel would have quite a few questions to ask these players, the claimants. Also, witnesses aren't being heard, yeah, and Christoph, you mentioned the 2016 judgments in which the Austrian Supreme Court basically considered the Austrian monopoly to be in line with EU law. Well, that's a pretty old judgment, right? So there is definitely new evidence that would be required, but the Austrian courts are reluctant to even hear witnesses, or obviously also to have a referral sent to the Court of Justice of the European Union. So that is why, in our firm view, the fair trial principles are currently not being adhered to by the Austrian courts. And as I mentioned, this has been raised to DG Just within the European Commission. That is currently still pending. But I do think that is one of the angles we still have to look at this from a slightly different perspective than only from the Austrian perspective.
And what of the process cost financiers? To me, they are at the heart of this situation.
Absolutely.
Because they are funding this avalanche of claims which otherwise wouldn't exist. There's talk of regulating them. What's the latest?
Yeah, so there has been an own initiative report from the European Commission, from the European Parliament that has been pushing for regulation of third-party litigation funders. As you said, they are at the heart of this. They are heavily advertising in Austria, not only on the internet and on social media, but even leaflets just being sent to basically everyone's post box. And this currently being a very openly advertised business model is also something that we are increasingly using in the proceedings. But back to your question, yes, there is talk about regulation that is primarily about having certain caps for what a third-party litigation funding company can take in the chunk of the claim they are funding, but also transparency. Very often, we as defending the gambling operators, we don't even know by whom such a claim is being funded. Yeah. So there is actually no transparency at all at the moment. That is one of the major requirements that is being asked for. Fiduciary care as well. So it's currently been sent to the Commission with a request to propose a text for a directive that has actually been annexed to the own initiative report. And I would assume that we will be seeing some more movement in that field in the course of next year, yeah, as of mid next year. It's been interestingly pushed by a group of German MEPs as well. But obviously the situation in Austria and in Germany, we're seeing an increased activity of litigation funding companies as well, will perhaps lead to a bit more momentum around this new regulation.
Christian, how do you think this will affect the current status quo?
overall, I think regulation is something that is really needed here, as you mentioned it, because it's completely intransparent. We come to court, we don't know, is the person financed, is this case financed, who is financing it? Then we had to find out that there's even cross-financing amongst them, so we really cannot tell who you're talking to. Short term, such a regulation, I think, could even accelerate the current proceedings and the current situation, let's call it, by process cost financiers trying to file as much as they can before any kind of regulation kicks in. Mid to long term, I expect a significant consolidation of the market because not all process cost financiers will be able to meet these high standards. And as Christoph mentioned at the very beginning, we have seen even new process cost financiers just popping up in the last weeks and months. So I think there will be a significant consolidation on their side. Another positive development, not only for us knowing who to talk to, will be increase of transparency also for the consumers, because this transparency will also bring a transparency to the cost structure and to the costing of these process cost finances that is significant when you look at the value of the claim itself. And generally speaking, overall, I think it will ensure higher professional standards and help creating a level playing field for all stakeholders.
A lot of up-to-date information from you. Thank you. Christoph, you've heard a lot. We've heard a lot today. How would you weigh in on this? Final comments, perhaps.
So I think the lessons you could learn from today's panel are, firstly, the player claims are here to stay. They will not go away on short term and will play a major role for the operators for the next month or even years. Secondly, also the litigation funding companies will stay in the market because the regulation, if any, will not apply on short term. And therefore, each operator has to evaluate which is the best strategy, how to tackle the players' claims. We have heard that there are different types of claims against different targets. So the operators have to evaluate and decide which is the strategy which fits best to their overall strategy and business model.
Just maybe briefly expanding on that, Christoph, what you've just said, because in our everyday practice, and it's the same for all three of us, we do see a lot of these claims. And at the end of the day, the litigation funding companies and the lawyers involved on the other side very often do make certain mistakes, and there are certain things that you can do better in that regard. So I totally agree. Having a solid strategy in place and really making sure that the claims are handled well, and that you kind of detect the errors that are being made. That there is a lot to be won in that regard. So I think having that solid strategy in place is definitely very necessary in order to navigate this situation, which is obviously very, very challenging for the entire industry at the moment.
Yeah.
And maybe just one last comment. What we've seen, you always have to stay alerted. Don't get into a routine. It always happens that someone makes a mistake, and we can put the finger exactly there. This can help, and on our client side, it helps a lot if they manage to build up internal structures, proceedings to make these processes efficient. Because we perfectly understand that this is nothing you want to deal with on a daily basis, but we want to help all of them bleed less, be more efficient, and try to handle this issue that needs to be handled, as Christoph said. They're here to stay. This will not simply go away,
yes.
And this is why we need to tackle it in the most professional and efficient way possible.
Thank you very much for your insights on this, and I'll pass on to Trudy again.